All right, so what we were learning about yesterday, I think maybe someone may need to restart the screen. I apologize. Uh, so we were in the middle of this tshuva where Rav Sharaga paskins that if the tenant was the one who put the
Rabbi, can you put up the page, please?
oh yeah, sorry.
Thank you.
If the tenant was the one who put up the tin corrugated top of the merpeset, the gagon, what's called, that the awning on top of the merpeset, and then it blew off, so the tenant is going to be liable. But if he never tampered with it, and it was reasonable for him to assume that it was securely fastened, so then the landlord is going to be liable in that situation. Now, let's just do the quick footnote. So he says on the sentence that im hasocher kibel tadir bofen shahagagon lahaya mechubar kira'ui, if he received the apartment in such a way where the awning was not properly fastened, imhu lo naga me'olam bigagon, but if he never tampered with it, he never touched it, it should not, the responsibility would not be on the tenant, kiven shabolam who's sheniachet hagagon shelo kahogan, because it's the landlord who fastened it to begin with. And the tenant had no reason to think that he had to check the awning to make sure that it was properly fastened. And therefore, we would say that in that situation, the tenant is potter and the landlord is going to be liable. So in the Makor Baruch just says, but what about if the tenant noticed it was going clang clang, and it was pretty loose? If the tenant sees, hey, this is not fastened well, and one day a wind's going to come and blow this thing off. Nira dezedami lamasha nifsak b'shulchan aruch. He says that would be analogous to what the Shulchan Aruch writes. Bebor shel shnei shutfim shaharishon hinicha megula, v'hasheni ra'ahu megula v'lo kisahu. He says it's the Shulchan Aruch gives the following case: a bore, a pit that's in a public area that belongs to two people, and the first, let's say it's owned by Ruvain and Shimon. Ruvain opens the pit and leaves it open. He neglects to close it. However, v'hasheni ra'ahu megula v'lo kisahu. But Shimon, the partner, sees that it's open and does nothing to close it, to cover it. It seems from the Mechaber that only the Ruvain, who's the guy who left it open, is going to be liable, and not Shimon, even though Shimon's aware that it's open. Amnam harama sham kasav diyesh omrim sheshneim chayavim, but the Rama says that both are liable. Kamosha kasav hasma sham b'pir das harama. He says v'im kein hachinami shahasocher ra shagagon lamunach kiroi v'lo tikno. He says here too, if the tenant saw that the thing was not fastened correctly and made no effort to fix it, or at least inform the landlord, l'das pashtus divrei shulchan aruch sham rak hamasker yechayev, but still, according to the mechaber, only the landlord is liable. But according to the Rama, there could be some liability on behalf of the tenant. So I don't know how secular law would look at this, but if I'm a tenant in a property and I notice, right? So you talked about that case of the glass, where the windows were falling all over the place. You'd have to make a case that the tenant either contributed to the thing falling off, or less convincing is the fact the tenant knew or should have known that this thing was going to fall off and did nothing, took no measures. But what if he says, well, I notified the landlord, and I said to him, it's not my job to fasten a portion of the bill of what you've affixed to the property and make sure that it's properly affixed. That's not my job. Right.
That would be the position in law, that if you had, and same thing with the municipal services, if it's a hit on your street, you phone the people to come and fix it.
Right.
It's not your job to fix it, but you notified them, that's acting reasonably.
Right.
Yeah, then you're not liable.
Okay, so that, I mean, that certainly makes sense. Okay. But then he writes, but if the tenant took it off before Sukkot and put it back on, then the tenant will be liable if it flies off because he didn't put it back, he didn't fasten it properly. So he says, Nira lidamod zinzel lahadi isa b'bava kama. He says, I think this is analogous, says the Makor Baruch, to a Gemara that we have in Bava Kama. Shim Ruvain chafar bar, uba Shimon umilehu afer v'chazer v'chafra. Ruvain digs a pit. Shimon comes and fills it with earth, and then Shimon digs it up again. So Shimon nechshav bal habor v'lo Ruvain da'achar shemilehu ba'afer nistalku ma'aser rishon. So we say that Shimon is the liable party, because even though Ruvain dug the original pit, but if Shimon filled up the pit and then redug it, we look at this as now Shimon's pit. Okay? V'chein pasak morin b'shulchan aruch v'zel loshono satmo ba'afer v'chazer v'hotzi et kol ha'afer ze achron chayiv shekivin shesatmo ba'afer nisalek ma'aser rishon. And he just quotes the Shulchan Aruch as confirming that. Ubir asma sham davi kilu lo chafra rishon me'olam v'asheni chafra me'chadash. And he said, and the Sma says it's as if Ruvain never dug a pit at all. V'lochein gam b'nidon didan yeshlomer shachar shasocher pirek et hagagon. So therefore, since the tenant removed the awning, arei silak pshias balabayas shelo hiniachas hagagon kiroi. In other words, the tenant could argue, well, I just put it back the way I found it. So what was I doing wrong? The answer is that if the landlord had put it up in a way that was not secure enough, and you go back and you say, "Well, I just did what the landlord did," that's not a valid defense, right? If you went ahead, took it off for Sukkot and then put it back. And therefore, the tenant has to assume full liability in that situation. Okay? All right, let's go. Let's go to the next tshuva. Nirdam b'nesiya v'nifzu hanosimito. This is a more serious tshuva because it's, could result in tragedy. The driver falls asleep and his passengers get injured. Okay? Ani v'chaveri nasanu yachad b'tramp. So my friend and I got a hitchhike, a tramp. Uve'emtza hanehiga hitnamnem hanahag. And in the middle of the drive, the driver nodded off. V'satame hakvish v'niftzanu shenenu. And he veered off the road, and both I and my friend were injured. Ha'im hanahag chayav l'shalim lanu et ha'hotzaot ha'refu'uyot udumei ha'avodah shehifsadnu. Does the driver have to compensate us for medical expenses and time off from work? Does it seem pretty open and shut?
Yeah, unless there's some medical issue you couldn't foresee or something, but if he was, fell asleep, he was probably tired.
Should have been.
That's negligence, yeah. But if it was kind of one of these own sin or something, like whatever, he had a heart attack, whatever, that kind of thing, probably.
But insurance would cover that, yeah.
Mm-hmm.
If he just fell asleep because he wasn't paying attention, it was, drank too much or something, he's liable for sure.
Okay. All right, so let's take a look at what the Shulchan Aruch says. Maran pasak b'Shulchan Aruch b'din adam shechaval b'chaveiro. So what's the case history? So we have in Choshen Mishpat Siman Aleph, the very first chapter of Choshen Mishpat, which talks about laws of damages. De bisman hazeh megavin rak shevet v'ripoy. He says today, as far as all of the additional damages beyond the cost of the loss of limb is that we also collect shevet and ripoy. We collect time off from work and medical expenses. And the other types of like there's another type of damage called boshes, and there's another type of damage called sa'ar, which boshes is humiliation and sa'ar is pain and suffering. Those are not collected by Beis Din, but time off from work and medical expenses are. K'mo shekasuv b'Torah, shivto yitain v'rapo yirapeh. So you have to, the Torah says explicitly, give him time for his Shabbos, meaning the time that he had to rest and recuperate and could not work, and rapo yirape for his going to the doctor, for his medical expenses. V'lo sha'ar chiyuvim shel nezek tzaru boshes. But the other three, which is the actual damage to the devaluation of his worth as a worker, the pain and suffering and the embarrassment, those are not collectible nowadays. Now, so the Makor Baruch says something really interesting. He says, Hine yadua dahayom she'ein lanu dayanim smuchim Moshe Rabbeinu. He says, nowadays, we don't have, the rabbis that we have today are not real rabbis. Did you know that? The rabbis we have today are not real rabbis.
Except you, of course.
No, I count myself in that category.
Not real rabbis, huh?
Not, in other words, there was the ordination of smicha is really only valid if you are part of a chain that can trace its way back to Moshe.
Huh?
So if I was ordained, if let's say Moshe ordained Yehoshua, and then Yehoshua ordained many of the Zikanim, and then the Zikanim ordained their people, and sometime in the times of the Tanoim, the authors of the Mishnah, smicha was broken. I think it was Yehuda ben Bava who was being pursued by the Romans, and right before they killed him, he was able to give smicha to 5 students, Rabbi Meir, Rabbi Shimon, I forget who the other ones were, and then from that point forward, there were very, very few actual people who could be part of that chain. In other words, the chain was broken at some point, and all subsequent people who get smicha, it's a borrowed term. It's not real smicha. From the times of the Gemara. Okay, so basically, ki nifsaka hasmicha kvar bizman haMishnah, that smicha stopped, that chain was broken in the times of the Mishnah. Lachein ein lanu koach hayom ladun ela bidvarim hamitzuyim tamid v'sheyesh behem chisaron kis. And therefore, even though back in the day, in the good old days, rabbis had more latitude to be able to impose penalties as they saw fit, today we can only rule on common cases and cases where there's loss of money to provide restitution. Because basically the Gemara says that the rabbis today are not acting with independent authority; they're acting with basically upon the proxyship of the public, and therefore they have to act more conservatively. And it's on that basis that the Shulchan Aruch paskins that when you injure someone nowadays, ein goven mimenu nezek tzaru boshes, kaven to dvarim elu ein bahem chisaron kis. You cannot collect the 3 that we just mentioned, which is devaluation as a worker, meaning that if you were to be sold on the slave market, you would fetch less money because you have this injury, pain and suffering and embarrassment. These are three things that don't actually cause you out-of-pocket loss, right? Only things that cause you out-of-pocket loss can a mazik be held liable bisman hazeh. Aval megaben ripoy v'sheves kevin sheyesh behem chisaron kis, right? That's the distinction. Ba'ayin sham b'ramah shekasav da'afal pi sheyesh omrim shegam sheves v'ripoy lo govim hayom al kol panim chayv hamazik lefayes hanechbal lefi ra'os einei hadayanim. Now, the Ramah, however, adds an interesting point. He says that despite the fact that we cannot collect, he says, even though there are those who say that even today we don't collect sheves and ripoy, time off from work and medical expenses, there is such an opinion. Nonetheless, the mazik is obligated to appease the injured party according to the discretion of the judges. So there's a little bit of wiggle room here, a little bit of ambiguity. I want to take a look at the Aruch HaShulchan and see what he says. But the bottom line is, let me just finish this paragraph. V'chol adam shegorem hezek lechaveiro chayev l'shalem. Anytime a person causes damage to his fellow, he has to pay for at least sheves and ripoy, bein shahaya shogeg, bein shahaya anus, regardless of whether it was intentional or not. Kemosha HaMishnah omeret bebava kama, adam muad la'olam, bein shogeg, bein mezid, bein er, bein yashen. You're always liable, whether you are shogeg or mezid, unintentional or intentional, whether awake or asleep. Now, so let's just take an interlude for just 1 second, okay? Let's see what how the Aruch HaShulchan lives on the cusp of the 20th century. So let's just see how he paskins as far as ripoy and sheves for just a second. Okay.
So Marvin, the secular law, you can sue for that, right?
Yeah, so secular law has economic damages and non-economic, called pecuniary and non-pecuniary. The non-pecuniary is pain and suffering, and the pecuniary is out of pockets, expenses, medical stuff. We get both.
I guess the pain and suffering is a little harder to collect that with him.
Yeah, the pain and suffering is where all the big money is for all these, yeah, it's a loss of earning capacity. If you render somebody incapable, give them a head injury, they can't work for 30 years or something, whatever, that's where the big money is. That's future loss of income.
That's where lawyers' big money is also.
Yeah, that's, you all want head injury.
Okay, here's the Aruch HaShulchan. Adam shechava, let me just make sure I'm sharing my screen. Sorry for those out there who can't see it. Let me just give it to you here. Okay, here it is. Adam shechaval b'chaveiro, ein megabin nezek v'tzar upegam uboshes, deleka chisaron kis bazeh. He says, if a person causes these damage to his fellow, we cannot collect nezek, tsar, pagam, and boshes. Even though if there's a loss of limb, person is not entitled to compensation for the loss of limb, and also not for his depreciation on the slave market, and pain and suffering, humiliation. He says there's no tangible loss of money in that case. He says va'afal gab de benezek yesh chisaron kis. Mikol makom lo shchiach chabala kazu sheyasalo nezek olam b'chisaron aver. He says, what about if you cause a person a loss of limb? He says there is a tangible loss of value. So he says, but it's not a common thing, and because it's not common, the rabbis did not impose it. Ve'alzeh amru chazal da adam ba'adam en govin oso bebavel mishum de lo shchiach. He says it's because it's an uncommon phenomenon, which is a surprising statement. Just because it's uncommon, does that mean that a person should be exempt from that? Right. So it's a little bit hard to understand, because you would think that the Torah imposes the payment for she'ayin ba'ayin, shein b'shein, yad b'yad, regel b'regel. The Torah says an eye for an eye, an arm for an arm. So I don't understand why, just because it's not prevalent, the rabbis would not uphold the Torah law. So it's a little bit hard to understand. V'harei anu roin dahakos ubizyano shchichi ella delasos nezek olam lo shchiach. So he says we do find that people do get into scuffles and do humiliate each other, but we don't find that people cause each other such damage that they permanently maim them. And that's the reason why. Zehu das Rambam zal, and that's the opinion of the Rambam. V'lachein kasav the ripoy v'sheves megaben bebavel mishum diyesh bazeh chisaron kis aval betzar uboshes. So therefore, the Rambam writes, he says, medical expenses, time off from work, that we do collect even in Bavel post-Mishnah. He says, because that's out of pocket. Aval b'tzar uboshes, but when it comes to pain and suffering and humiliation, v'chein b'makom sheyesh pegam, kagon ba'ones u'mefate, he says, and also when you devalue the person. So therefore, the example would be if a man rapes a virgin or seduces a virgin and then causes her devaluation on the marriage market. So then, ein bazeh chisaron kis, he says that doesn't involve a tangible out-of-pocket expense.
What about the amount of the ketubah?
Well, yeah, but she doesn't have that right now. In other words, you're not taking anything from her that she has in hand, right? If a guy's got a job and he can't go to work, you're taking his job from him. Okay. Skip the brackets. There are some of our rabbis who also opine, and this was quoted by the Ramah, that you can't even collect sheves and ripoy, which is time off from work and medical bills. Why? He says, because they felt that it was referring to all 5 things that the Gemara describes are collectible for damages. There are some opinions that say that once smicha ended, the rabbis lost all jurisdiction over cases of damages completely. V'zehu das harosh v'hatur. He says that's according to the Rosh and the Torah. V'im kol zeh gam l'deyazu kovenes hachoyvel l'chayev lahanechbal k'fi erech hanira l'dayanim. But nonetheless, even according to that opinion, the dayanim have a right to coerce the damager to appease the damagee based on what they feel will be a reasonable amount to compensate him. Kain kosav Rabbeinu Harama. So according to the Ramah, it's just like basically all discretionary in the hands of the judges to determine what would be a reasonable amount to get this guy to at least not feel that a miscarriage of justice was performed. V'chein behema shehizika adam ein danim mipnei she'eino matzoi. He says also when animals cause damage, the rabbis do not adjudicate over cases like that because it's not prevalent. Aval adam shahazik behemas chaveru mishalim nezak shalim b'chol makam. It's only when a man causes damage to property, such as of his friend's animal, that is prevalent, and that's something that we adjudicate upon and based in all the time. Because that's more common. It's more common for a human to damage the property of another person than it is for a person's property to damage a human. And furthermore, if an animal actually damages with things that are prevalent, so for example, it kicks, or it bites on something and then causes damage, that's prevalent. But if it's an animal that gores, that's not common. Ein danim shezelo shchiach. V'chein behema shaharga adam ein kofen oso based in sheyishalim kofer dezelo shchiach. He says similarly, if an animal kills a person, The Beis Din will not place any additional payments because it's not prevalent. The Shach even says that damages through Eish and Bor, which we've been talking about all along. The Eish Omrim Shedanim Dematzi Leprokim, and some say that we do judge them. The Iskimu L'Deyazu Kama Migdoli Achronim, and this has been the consensus of many of our latter sages. V'chein nira ikar ledina, v'chein mashma berambam perak yudal benizkei mamun din yud beis, etc., etc., etc. Mikol makom kofin lebal hashor sheyivaret hamazik, kemo sheyizbar b'simin tavtes shekol echad mechuyev levar mirushusa davar hamazik la'acher. But one thing we can compel the damager is that he has to remove the source of damage. So this is really all pretty shocking. It's denuding the Beis Din bisman hazeh and basically saying Beis Din can withdraw itself from certain cases of damages just because these cases are not prevalent. And it could have to do with the issue of expertise, I don't know. But it seems from the language of the Aruch HaShulchan that there are so many instances where a Beis Din can essentially say, we're not hearing this case.
That means you have to go to the government.
It might be that you have to go to the government. It might be. However, you have to also be careful. Today, there's nothing wrong with going to the government because the government uses just law to not favor one party over the other. But what if it's known that this particular country where I live in, they come down so hard on a damager? Let's say I live in a Muslim country and they will cut off my arm because I accidentally hit someone when I was driving, right? Or something to that effect. Like I don't even know. You'd have to consult with the rabbinic authorities of the country in which you live. But generally speaking, even today, our Batei Din in North America generally don't hear cases of damages. They generally say, we're not going to hear these cases. We give you permission to go to secular court. That's generally my experience. Okay, so we'll have to deal with this issue tomorrow because we have to find out what Rav Shiraga paskins for the situation in Eretz Yisrael. Okay, so we'll hold it here.
This was the case with
With what?
this was still the